Okay, we are streaming. Shannon, you can put us on the record now.
Yep, got us.
Counsel, this is a matter of Gibson versus M&M Corp. Could each of you state your appearances, please?
Certainly. David Cleavorn on behalf of Defendant M&M Corp., P number 80043.
Wallace Kylan, co-counsel for Defendant M&M Corp., P78291.
Bethany Smith, counselor for the plaintiff, Golden Gibson, P number 57913.
Were either of you or any of you expecting clients to log in? I do have a device in the waiting room. It doesn't have a name associated with it.
I was expecting Mr. Gibson to log in and watch.
All right, let me see if that's him. Yes, that's Mr. Gibson.
Yes.
Okay, good afternoon, Mr. Gibson. Okay, so who's arguing defendant's motion?
I can proceed, Your Honor, if you're ready for me. David
I
Cleavorn.
am, go ahead.
All right, Your Honor. So this is a defendant's motion for summary disposition. I won't rehash the pleadings. I know you've read the briefs. I would say from reading.
I'll tell you, I did read the briefs, but I'll tell you what I didn't read was whatever contract is in dispute here. I've got two contracts. I don't know which one is the one that governs, that are both illegible. Does anybody have, one looks like it's a very long form contract, but I couldn't read anything on it. And the short contract, and I can't remember which exhibit number it is, I couldn't read that either. Do either of you have a legible copy of either of those contracts?
Your Honor, I never could get a legible copy. That contract was drafted by the defendant, but I did put the wording of the contract. It took me a bit of work to figure it out, but I did put it in. I'm trying to find.
All right. Well, I did see that, and I wasn't sure where
it's at the bottom
where it came
of.
from.
Your Honor, it's at the bottom of page 6 of my reply brief.
So Exhibit A to somebody, I believe it's Plaintiff's Appendix, is the short one paragraph contract that looks like the parties signed, or at least somebody signed on 12/5/19.
Yes, and then there's an attachment to the one paragraph contract that lists a number of personal property items that the defendant was going to be taking.
A very short, it's called Attachment A.
Yes, I believe so.
All right. So what's this other contract that I saw?
Are you referring to the purchase agreement between Mr. Gibson and his buyer for the salvage yard?
Maybe that's it. Let me find it. I think it did say purchase agreement on it. Yeah. So yes, this is Exhibit A to Defendant's Appendix. And so I couldn't read any of that. So that is the purchase agreement between Mr. Gibson and whoever it is he sold the property to?
Yes, that's correct.
And that's being submitted for what purpose?
My motion does not rely upon that purchase exhibit at all, Your Honor. Relative to the purposes of my motion, the contract that governs would be that short little one paragraph thing. And I think a more legible copy, it is counsel did type it out. Bottom of page 6, top of page 7 in her responsive brief. And that appears to be the most legible copy we have, because there wasn't between the parties a very legible copy produced. But it's a one paragraph agreement, and that is the contract. That is what governs the relationship between the parties.
Okay, tell me
Here-
again where I find that language typed into somebody's brief.
It's on the bottom of page 6 of the plaintiff's reply.
Okay, hold on.
In your honor, the reason for the inclusion of the purchase agreement is simply to show that the plaintiff had an obligation to have the property cleaned up, during a certain time period, and that didn't happen, and he suffered some financial injury as a result. That's the purpose of that.
All right, so that
Yeah.
might be relevant to show what his damages are, but it's not relevant to the contract, the contract that exists between the parties to this lawsuit.
That's correct.
Correct.
Okay, so Mr. Cleavorn, has plaintiff accurately transcribed that contract in her brief? I mean, are we in agreement? That's what it says.
As far as I can tell, those terms appear to be the terms that I'm reading in the less than ideally legible contract. But yes, I think that transcription, I'm comfortable with using that languages for the purpose of my motion.
All right.
I apologize for the illegibility of it. Much time was spent with the copy machine trying to darken that up, but it just didn't happen. It just wasn't going to happen.
All right. Well, thank you. I'm glad I at least know which contract I'm supposed to be looking at.
It's
So
an important step one, right?
It certainly is. All right, go ahead.
All right. And so again, Your Honor, looking at that contract itself, and I guess just as a preliminary aside, I should say, it appears that count 4, quantum merit, is no longer contested. I believe sister counsel's responsive brief said that they weren't going to be pursuing with that. So I think that one I don't have to address. But relative to the contract language, as you can read in those terms, the agreement is that my clients paid $55,000 in cash for 270 vehicles, 2 loaders, 65 engine cores, forklifts, car hoist, air compressors, and small parts. That is the contract. We pay cash for these items. And so,
well, and isn't the claim that your client didn't take all of those items, but in fact ended up leaving many of them for
no, Your Honor.
That's not part of the claim.
That is not part of the claim. The claim or allegation is that my clients did not put the property then in broom clean condition, or essentially clean up the scrapyard in addition to removing those items. So as you can see, there's no term in there that references any sort of obligation on my client's part to clean up the contract. And if we've exchanged discovery and pleadings, they're alleging there was some sort of contemporaneous oral promise to clean the property. And they've taken the position that the only consideration alleged in exchange for this broom clean obligation was a discount in the $55,000 price. And so the problem that plaintiff has with that consideration in a reduced price is twofold. And first of all, even in a light most favorable to plaintiff, assuming his complaint is well pled, then this is a mixed goods and service contract governed by the UCC, because we've got $55,000 in goods and it's listed the items that it's exchanged for. Again, there's no mention of the service of cleaning it, but by plaintiff's own admission, there's no written agreement which codifies this supposed agreement to clean the property. And as a contract for the sale of goods over 1,000. Yes, Your Honor.
Let me stop you for a minute. I saw the phrase broom clean mentioned several places. Where does that come from? Is that from the complaint?
That's from plaintiff's complaint.
How do you broom clean an auto salvage lot?
You got me.
Your Honor, it's just a real estate term that's used in most real estate agreements. It just means the property has to be cleaned up.
I understand broom clean where a building is concerned because it's got a floor and you can actually sweep it out. It has some meaning. Broom
There
clean
is
has no
also,
meaning.
Your Honor, there
With
is
respect
also
to-
a building involved here that was supposed to be put in broom clean condition.
Well, I mean, I could apply broom clean to the building. I can't very well do that to the grounds.
Well, perhaps it wasn't the best wording to use, but I think throughout my reply and in the complaint, it makes it clear that the defendant the plaintiff thought the defendant was going to clean up the property.
And therein lies the problem, Your Honor, is just because Mr. Gibson thought that my client was going to clean up the property, there's no evidence whatsoever in this contract submitted or exchanged in discovery which actually codifies that obligation. If in fact they're taking the position that my clients were under an obligation to clean the property and received in exchange for that a discounted price to $55,000, that has to be in writing. This is subject to the statute of frauds because it's sale of goods over $1,000. And so it's not in writing, it's not admissible, it's not enforceable. And if they're trying to argue that it's ambiguous. Sorry, go ahead.
Would you agree that there could be theoretically an oral agreement to clean up the property that would be enforceable?
For what consideration? If in theory there is an oral agreement to clean up the property, what's the consideration for that? The only thing that they've alleged is a discount in price, and the price is in the contract. There's no mention of a discount. I actually have a case directly on point, and I apologize, Your Honor. I hate to do this. I really wish I would have discovered it when I was writing the initial motion and reply brief, but just in preparing for oral arguments, I found a Michigan Supreme Court case with nearly this exact situation. And so I'd be remiss if I didn't bring it before the court because it's directly on point. And the case is GMC versus Alumi Bunk Incorporated, 482 Mich 1080. It's a 2008 case. Again, that's 482 Mich 1080.
Your Honor, if I may interrupt, I got no notice of this case. I don't think it's appropriate for him to argue it when I haven't had any opportunity to read it.
I certainly, if you need more time to be able to respond to it, I would grant you more time. But if there's a case on point, I certainly want to be aware of it.
And that was my intent as well, Your Honor. Obviously, if I was aware of this case, you bet your bottom dollar I would have put it in my motions and pleadings. I only discovered it when preparing for oral argument. But the gist of that case is it was a breach of contract frauds case similar to this present matter. In that case, the defendants were car dealerships purchasing 148 vehicles from GMC. GMC claimed it offered a discounted price in exchange for the additional service of modifying or upfitting the vehicles before selling them. Essentially said there's market segmentation. Whatever these dealers would be putting in the market would be unique or different from the general GMC line. There was even contemporaneous emails discussing the discounted price in exchange for upfitting. And the contract in that case did not contain a merger or integration clause. But at the end of the day, the ultimate written contract did not speak to any supposed discount in exchange for upfitting, despite the fact that there was emails that referenced that. And so the trial court and ultimately the Michigan Supreme Court held, if you wanted that term in the contract, if the purchase price is supposedly reflective of this discount in exchange for upfitting, then the contract should have included that term. And so the trial court and ultimately the Supreme Court dismissed not only the breach of contract claims, but also the promissory estoppel ones and also the tort ones that are similarly pled in this case, such as fraud, misrepresentation, things like that. And so, Your Honor, again, I would have put this case before you had I discovered it earlier, but I think it's incredibly on point. and certainly worth consideration, because again, that's the exact situation we have here. They're claiming as part of the contract was a reduced price in exchange for this service. that doesn't appear anywhere in the contract language.
So the contract involved here, the actual written contract, is incredibly brief. It doesn't have any kind of a merger clause in it. How does that impact your analysis here?
Only impacts it because even without a merger clause, there's no term within the contract that's ambiguous, because you're only going to allow in that parole evidence if there's some sort of ambiguous term that's subject to more than one meeting. And you're not going to be able to find a single term in this brief paragraph that touches on or even alludes to clean our property in exchange for a discount. There's just not a term in there. And so there's no ambiguity. So, I mean, just like the GMC case where there was no merger integration clause, there's not one in this brief paragraph, but that didn't prevent the court in GMC from dismissing the case in its entirety as a matter of law, just given that, look at these plain terms. There's no interpretation that could possibly be read or understood as a person has seen. Oh yeah, I see. There's M&M's obligation to clean the property right in this term, or that's how this could be interpreted. So, absent some sort of contractual language that references it, or even an ambiguity, there simply can't be enforced a contractual duty onto my client that doesn't exist.
So this contract does say that your client will also not be responsible for contamination cleanup. Why would that clause be in this contract if the only thing involved is the purchase of these specifically named items of personal property?
In the process of removing the items, they're just saying they're not going to pick up after any sort of contamination from removing the vehicles, from removing the air compressors, the small parts, or anything like that. It's the debris. My client is a metal buyer. They purchase metal. They've never been in the business of cleaning properties. And so really that's just further solidifying that all that was occurring here was an exchange of cash price for these specific items that my client was purchasing as a metal buyer.
Your Honor, may I ask, since it's been a very long time since I've been in front of you, are you expecting me to reply to Mr. Cleavorn after he finishes talking, or am I waiting until I have my own turn once he's completely done?
Well, let me finish hearing from him and then we'll hear from you.
Okay, thank you.
Okay. And so to continue.
So in this case that you cited, which I have in front of me, but obviously haven't had a chance to read, was there an extensive written contract that contained these, the typical merger clauses, no other representations? This is the entire agreement of the parties?
There was, I believe, let me pull it up, but I believe there was no merger integration clause. Let me pull that up. And so I apologize. It wouldn't be in the Supreme Court opinion, but it was taken on appeal. So the procedural history, the Court of Appeals on a 2-1 decision reversed part of the trial court's grant of summary disposition. But there was a dissent, and that's referenced in the Supreme Court opinion. They say we're reversing for the reasons consistent with the dissent. So in the Court of Appeals case, it says right on page 4 that the written agreement related to the cap discount was not integrated. Therefore, parole evidence was admissible to determine the intent of the parties for ambiguous terms. So from the language there, I'm not seeing the full contract or the length in it, but the Court of Appeals record suggests that that particular contract was not integrated.
So, and then the ultimate holding was, despite the absence of an integration merger clause, that parole evidence rule barred evidence of a separate oral agreement, contemporaneous oral agreement.
Given that there wasn't an ambiguous term, they listed the price, but because there was no reference in the contract language to here's the reason for the discount in the actual contract, that was why the summary disposition was granted.
All right.
Judge, Attorney Kylan in this matter is in the waiting room. We lost internet.
Oh, sorry. We lost one of our attorneys.
Better let Ross back in.
We'll let him back in. I didn't notice. Thank you, Peter.
Yeah.
All right, Mr. Kylan is back with us. So go ahead.
Your Honor, the joys of technology.
And so
make sure you pay your cable bill.
That would help. I apologize for the disruption.
No problem.
And Your Honor, really the gist of addressing counsel's position that the consideration in this contract was in exchange for this discount, in exchange for the service. That was why I wanted to bring up the GMC versus Lumi Bank. I think I've addressed or touched on all the other points I wanted to touch on. I think that my pleadings and briefings speak for themselves on all the other issues. I have nothing further to add on this time and would rely on my briefings. Ross, I know you've been off due to internet issues, but do you have anything to add?
I think out of respect for the court, I'll defer to counsel on this. I don't want to be redundant as to points made. I think the brief is self-explanatory as to the issues, and despite some efforts which could complicate them, I don't see this as a terribly complex issue. So unless Your Honor has specific questions for me, I'll defer to Mr. Cleborn.
Thank you. Ms. Smith, it's your turn.
Okay, Your Honor, before I get into my argument, I'd like to talk about this case that Mr. Claiborne brought up, the General Motors Court versus Lumi Bank. I did pull it up on my computer. His site is only it's a one paragraph. We go ahead and say the trial court was okay to do what they did. So there's no real detail for me to look at. But I do see in the concurrence, they talk about there was a singular promise that was the sole reason for the dispute between the parties. And that is not the case here. There's not a singular promise. There's promises to clean up and there's promises to remove items. And then there's also issues of vehicles that disappeared, vehicles that were damaged, personal property that was damaged. This isn't a single issue case. So just based on what I can see in this Supreme Court decision, I don't think that this case applies to our situation. But then again, I don't have the cite to the actual Court of Appeals case, which has all of the facts and real information in it. So
I can provide that cite if you want.
With respect to any claims that things were taken that they shouldn't have taken, or things were damaged in the course of taking them, clearly there are questions of fact on those issues. I don't see how I could possibly resolve those issues today.
thank you, Your Honor.
And with respect to the Supreme Court case, and apparently we're going to have to read the Court of Appeals opinion as well, concurrent or dissenting opinion. Ms. Smith, in fairness, I will give you a full opportunity to address that. So I'm not going to be able to make a ruling today, but I will certainly listen to the arguments, and we'll have to leave to a future date whether or not this opinion does indeed foreclose the claim of a contemporaneous oral agreement.
Well, Your Honor, I'd also like to say that Mr. Claiborne himself said when he was looking over the Court of Appeals case or whatever he was doing, that he said parole evidence was allowed. So I don't think this case even works for them. I think it works for us, because that's what we're saying. We're saying this contract's ambiguous and parole evidence to be allowed. He's saying that that's what this case said.
I haven't had a chance to read it, counsel, and without reading it thoroughly, I'm not in much of a position to agree or disagree with you.
I appreciate that, Your Honor. Okay, well, I guess I'll go ahead and, although I always like to be brief for the convenience of the court, I think there's a lot of issues here. There's a lot of counts. The defendant's trying to dismiss them under C8 and C10. So there really is a lot to talk about. So I apologize that I can't be brief, but I want to be able to make sure that the court understands from my client's perspective what was going on here. As you know, he owned a salvage yard and he was selling that salvage yard. And part of his obligations when he was selling it was to have it cleaned up. So everything on the outside and everything inside the building needed to go before the new owner closed on the property. So the plaintiff contacted the defendant about cleaning up the salvage yard, and they agreed that the plaintiff would sell the defendant 270 vehicles plus all those items listed on attachment A, and in return, defendant would clean up the salvage yard. And the price that the plaintiff gave to the defendant for the 270 vehicles was dependent on the defendant's promise to clean up the salvage yard. In other words, it was that price was reduced because of the expenses that the defendant would incur in his cleanup of the salvage yard. And if you look at
Ms. Smith, let me stop you.
Okay.
If the cleaning up of the property was such an important thing for Mr. Gibson and crucial to his agreement to sell at a discounted value all of this, I guess what eventually became scrap salvage metal, why wasn't it in the agreement?
Well, Your Honor, Mr. Gibson is a very clever man, but he is not an attorney. And if you look at the last few sentences of this agreement, they say, we will not be responsible to remove any boats or motorhomes. Why is that in there if they're not responsible to remove something? And then it says, we will not be responsible for contamination cleanup. Why is that there if they weren't responsible for some type of cleanup? The fact that those two sentences exist.
Wait a minute. I mean, in order to realize the value of what he's purchasing, M&M Corp would have to remove those items. That's the only way they could realize the value for those things is by removing them. And here it says we don't have to remove this other stuff.
Well, I mean,
your point is,
I'm sorry, Your Honor. I mean, it does say 270 vehicles, 2 loaders, 65 engine cords, etc. But then it goes on to talk about removing boats or motors. So something other than 270 vehicles, 2 loaders, 65 engine cords, etc., and boats and motorhomes were supposed to be removed. I think that's the only reasonable reading you can get from looking at that sentence. And then if you look at the we will not be responsible for contamination cleanup, why even say that if you weren't responsible for some cleanup? It would be completely unnecessary. So the fact that those 2 sentences are in there is a big indicator that the plaintiff is correct, that he was told by the defendant that he would clean up the property. And I don't think that you can make any other sense out of this contract other than to think that. I mean, there's no reason for those 2 sentences if the defendant is telling the truth. If the truth is he wasn't supposed to remove anything or clean up anything, he didn't need to put those 2 sentences in there. So obviously there was something broader going on, some larger agreement than what this silly 1-paragraph agreement says.
Ms. Smith, did you make any attempt to transcribe the attachment A to this 1-paragraph agreement?
I did, but Your Honor, I think I didn't attach it onto my reply. I do have one somewhere. It took me a little while to do it, but basically it's just, I can't remember all the items, but it's basically 8 items of personal property that they were going to take in addition to the 270 vehicles, 2 loaders, etc.
So I can read big red compressor, Coates, which I assume is a brand name tire changer. And then above that, I can't make it out at all. Above that, it looks like a brand name forklift. Although I thought I read that a forklift was included. Yeah, it says forklifts plural. I believe I read something that Exhibit A, at least the body of it, was prepared by the representative of the defendant. Is that correct? Am I correct on that?
Yes.
What about this attachment A? Looks like it may have gotten added.
I am looking for that. I did send that to the defendant. I tried my best to transcribe it, and I wrote in the bottom, I said, for ease of reading, and I listed off what it said. And I'm trying to find that. I apologize. I thought I had attached that copy onto the complaint, but
question is,
oh, here it is. I found it. It says Ingersoll Rand VR 9012, Heister dual weld forklift high-low, Trojan 1900, 19-1148, 245 cars, Mohawk car lift, Burwell car hoist, Coach tire changer, and big red compressor. That's what I can tell from that.
Who prepared that?
I believe it was the defendant.
Well, it seems odd that the defendant would have typed the agreement, but then handwritten the attachment. So does anybody know with certainty who actually prepared the attachment?
I can't speak to that, Your Honor. I certainly could follow up with my client. Ross, do you know one way or another on attachment A?
Not with certainty, Your Honor. I do not.
Well, Mr. Gibson's present. Let's ask him. Mr. Gibson, do you know who prepared the handwritten attachment A?
It would have been M&M Core.
It definitely wasn't you.
No, it wasn't me.
Okay, thank you. I'm not sure it makes a whole lot of difference. I was just curious because it was in a different format. All right, go ahead, Ms. Smith.
Okay, as I was saying, the plaintiff believed that everything would be removed by the defendant except for these boats and motorhomes, and that everything would be cleaned up in a salvage yard with the exception of the contaminated areas that are referenced in the 1-paragraph complaint. And why did he believe these things? Because that's what the defendant told him. So there was a broader agreement than just selling cars to the defendant. And these 2 sentences at the end of this 1-page agreement, it's our contention that this makes this an ambiguous contract, because you need to take a look at it and see, are there some facts that show that there was something more to this agreement than just what's written in this 1 paragraph. So what happened was the defendant, he took his 270 vehicles and stuff on the attachment, the other few things, whatever he could sell for money, I guess, and left the rest. And also during the time that he was removing these items, several vehicles, which were not part of the 270, just disappeared. And others that were not part of the 270 were damaged by defendant and its employees. And defendant admitted to plaintiff that those were taken by accident and damaged. However, there was no money given to the plaintiff to make the repairs to the damaged property, and the vehicles were never returned. So basically, once the defendant had removed everything that it considered to be of value to it, it just didn't do anything else and left everything for Mr. Gibson to take care of.
What else? What was left? What was left?
Oh, Your Honor, there was so much left. If you watched the site visit video, you could see all of the stuff that was left.
I
Basically,
did
the
watch
whole
it.
salvage yard was still covered with property and materials and things like that.
Okay, I did watch a good part of that video. I'm surprised whoever it was that was carrying the phone or camera didn't collapse of a cardiac arrest.
Yes, that's
That poor
the truth.
guy. That poor guy was breathing so hard. I was worried for him.
He has some physical difficulties.
In any event, what you're telling me is what I saw on that video is everything that was left after the defendant had removed the things that it wanted.
Yes, and after he never returned to do the cleanup. So about that video, the plaintiff contacted the defendant. He asked him to come out to the salvage yard and talk to him about his obligation to clean up the property. So the defendant drove, I assume, from Bronson, Michigan, which is where his business is, which is over an hour drive each way. He met with the plaintiff. He walked around the salvage yard with us in the freezing cold. And again, he agreed he was going to clean up the property. And we had that video taken. And I didn't transcribe the whole video. I admit that. But I pulled out some snippets that I think the court should know about that are important to determining this today. And most of these are said by Mark Roberts, who I am assuming is the main representative for M&M.
That's what I was going to ask, is who that individual was. You said his name is Mark Roberts?
Mark Roberts, yes. He was the main speaker when we met with him at the salvage yard about cleaning it up.
Is that the same person that Mr. Gibson met with when he signed the written agreement?
Yes.
Go ahead with the snippets.
Okay, so Mark Roberts says, anything that's metal we can take. Then a few minutes later, he says, I'll take some of these, I forget what he was pointing to, and throw them in carts. He says to his employees, Mike and Les, do you understand what goes? Let's get tubs and trucks, whatever we got to do. Get a crew here, get them out of here. They talk about bringing a low boy in to remove stuff. Mr. Roberts and I had a small discussion about having a final inspection after his cleanup was done. That's at 7:25 in the video. There was a discussion about whether a red truck that was inside of the building was going to go. That was the word they were using most of the time. And then I asked Mr. Roberts, this is at 15 minutes into the video, I say, are you guys taking all of this stuff? I didn't get an answer, so I asked him again, and he replied, yes. And you can plainly hear that on the video 15 minutes in. Then further along, they discussed whether certain tires were going to be removed by the defendant. And then towards the end of the video, Mr. Roberts says, we're just going to come in here with dump hoppers. We're going to fill them and take them away. He talks about getting trailers and getting stuff out. He says, we can pick up dump trailers to get the smaller stuff. And then he says, make sure everything goes to his employees. Make sure everything goes. I think that's the most important statement in this whole video.
Well, wait a minute. Wait a minute. I remember hearing him say, anything that's metal, we'll take.
He did say that at the beginning.
Tires aren't metal. And there's a cost for disposing of tires that's pretty significant.
That's true. But as we went along in the site visit that day, he did indicate that he was taking things other than metal and other than tires. And in the video, you can see the plaintiff and the defendant, they walk around practically the whole yard. They go into the building and have discussions about what's going to be taken. And I think that the very fact that Mr. Roberts came to this meeting shows that he knew he had some obligation to the plaintiff to remove items from the property. Otherwise, why would he have even been there? What would be the point of him even showing up? He's going to drive 2 hours to talk to him about something that he has no obligation to do. That doesn't make any sense. So obviously, from his visit and the things that he said during his visit, he knew he was supposed to clean up the property.
So after that visit that I watched on the video, did anybody from defendant return again to the property to remove anything at all?
No, Your Honor, they never did. And I think something that one of Mr. Roberts' employees said in the video to me is the real explanation for why he never came back and did his part as far as cleaning up the property, and that's expense. His employee says, let's see, let me get at 11 minutes and 15 minutes into the video, he says, the landfill charges for this shit is easily going to cost $4,000 or $5,000. And he was worked up when he said it. So I think that shows you that maybe plaintiff at the beginning thought he was going to clean the property up, and then he figured out how much it was going to cost him, and then he backed out. I don't know, but I think the video shows his true intention when he entered into the contract was to clean this property up. But probably because he discovered it just wasn't going to be worth the money to him, he just never followed through on it. So eventually,
So did plaintiff have to hire somebody else to come in and clean it up to his whatever was
Yes,
required in order to sell the land?
Mr. Gibson had to delay the sale a time or two, but finally he found another contractor that would come in and clean up the salvage yard. And I believe it was about $13,000 that he had to pay in addition to this new contractor. And that's after having given M&M Corp a reduction in the sale price for all those vehicles and personal property to, offset their expense for doing the cleanup of the salvage yard. So, he lost out twice, really.
And this oral contract that you are alleging, the two principals involved in that were Mr. Gibson and the representative of the defendant who was prominent in the video?
Yes, Your Honor. In addition to the odd wording that's contained in the contract, this isn't an integrated contract. It doesn't say it bars any other, contemporaneous or parole oral discussions, which is normally in a contract. So the fact that it doesn't say that the court is allowed then to go ahead and, aside from the parole evidence rule, look at the facts and try to determine what the real meaning of the contract is. So the parole evidence rule, with all of these odd things going on, the language in the contract, the site visit, the Mr. Roberts saying he's going to clean up things when it comes to the site visit, plaintiff's allegations in his affidavit that he was told he was going to clean it up. With all of these things going on, I don't think that it would be appropriate to dismiss the breach of contract claim based on a C8 motion just because the defendant says the parole evidence rule, bars everything. It doesn't. The parole evidence rule in this case, it's not going to vary or contradict the writing at all. So extrinsic evidence is allowed in to see what the true intent of the parties was. And plaintiff alleges the true intent was a lot broader than what the defendant's saying. And I feel that we've provided ample evidence to show that is a very great possibility that plaintiff is correct, that this involved not just a sale of vehicles of personal property, but an obligation on the part of the defendant to clean that property up.
All right. I've got another hearing that was scheduled at 3:00 and that I need to get to. What I'm going to do, Mr. Cleavorn, if you would like to file a supplemental brief that elaborates on this case that you cited and points to what you believe is the most relevant holding of the case,
Yep.
How much time would you like to do that?
I anticipate I could get that. Do you have an intended scope of the brief and length, Your Honor?
I'm not going to limit you,
Okay.
but I just, rather than just pointing me to the case, if you
Yep.
want to elaborate in a brief what you believe the holding is and why you believe it's dispositive,
Yep.
I wanted to give you the chance to do that. And
Sure.
then I want to give Ms. Smith an opportunity to respond to that. And I don't really care about the time frame. We're a ways away from being able to conduct a trial anyway. So would 2 weeks enough? 3 weeks? Tell me
2
what
weeks.
you'd like.
2 weeks should be sufficient. I think I can get something
All right.
filed within
And then
14
Ms.
days. Yep.
And Ms. Smith, can you respond within 2 weeks of that?
Yes.
All right, let's do that. Once I get it, if I believe I'm able to make a ruling, I'll just rule based on that. if I end up having more questions, I will get a hold of you. We'll set a date for further arguments.
All right.
Your Honor, is there one more quick thing that I can say about count 7, which is the innocent misrepresentation? I don't believe that I pointed it out in my brief. So I just wanted to say quickly, the defendant says we didn't make an allegation about there being a material misrepresentation. I did say in paragraph 68 that the defendant made a representation. I talked further on in paragraph 72 about it resulting in an injury to the plaintiff, which to me, if a misrepresentation results in an injury, it's material. But I didn't have the word material in there. I do apologize. So if the court finds that to be something that's, I guess, not good for our case, I would ask that you allow us to amend the complaint so that I can add the word material into paragraph 68.
What's the innocent misrepresentation that you're alleging?
That that the defendant made a promise that he was going to clean up the salvage yard, which he didn't do.
So he represented that he was going to clean it up. Yeah, I guess I have trouble finding how that gives rise to an innocent misrepresentation claim, but in any event, I will address that when I make my ruling.
Okay,
Sure.
thank you, Your Honor.
All right, thank you, everyone.
All right. Thank you very
Have
much,
a
Your
nice
Honor.
day.
Okay, and let's see. Sorry we kept you folks waiting so long. Hoffmeister versus City of Jackson. Well, Mr. Ellison's not in yet.
Saw him a moment ago, Your Honor.
Looks like he's hung up. There we go. All right, looks like we've got both of you here now. Counsel, if you could each state your appearances, please.
Good afternoon, Your Honor.
Go ahead.
Nice to see you again, albeit virtually. Matthew Haggerty on behalf of the City of Jackson.
Good afternoon, Philip Ellison, and I have no tires to talk to you about at all today.
So before we wade into this motion today, my law clerk's been working on the motion that I've already got under advisement. And he took the opportunity to look into the city code, particularly as it pertains to income tax withholding, and was able to put his hands on a JW4 form, which is the withholding certificate that employees give to their employer, designating what they want the employer to withhold. And I see for paragraph 3 of this W4, titled Predominant Place of Employment, it says print the name of each city where you work for this employer and circle closest percentage of total earnings in each. There's a place to write the names of 2 cities. And there are categories: under 25%, under 40%, under 60%, under 80%, and then, no, I'm sorry, under 25%. And then from there and up, it's not under. I was misreading that. 40%, 60%, 80%, and 100%. So presumably, every employee of Consumers Energy has the ability to fill out this withholding certificate and submit it to their employer. And then the employer withholds based upon the information provided by the employee. Isn't that how this is supposed to work?
It is how it could potentially work, but as the evidence that I'm presenting today, as the email from the city, from the Consumers Energy establishes, that it's the position of the city that working from home means working still on site and still requires
Who cares if that's what the city thinks? The employee fills it out based on what the employee thinks. The employer that withholds on that basis, and then at the end of the year, if the employee's wrong, he ends up having to pay more taxes than was withheld, or he gets to challenge the attempt by the city to impose more taxes than what were withheld. Where's the city involved in that process? I don't get that.
Again, we're at the pre-discovery stage on this, but it's my understanding. First thing is you're looking at this backwards, Judge. This is a form that would have been filled out at the beginning of the employment relationship, not at the time when COVID would be known in that respect. So if you're in March of 2020, right, and you
all right, let me stop you. Let me stop you because I don't agree with what you just said. Yes, you fill this out at the beginning of employment, and yes, every time your place of principal business fills it, you fill out a new form and you give it to your employer because there's been a change in circumstance. Clearly, there was a change in circumstance here. These people are working from home now instead of working at their offices in the city of Jackson. Why don't they just fill out a new form and submit that to the employer? If they don't, wait a minute, let me finish.
Sir.
If they don't do that, what in the world is the employer supposed to do other than withhold based on the form that they got?
That's what makes the email today so important is that it's the city's position in the work in the conversations and the negotiations between Consumers Energy. And we're using consumers as our bellwether, right? For all employers, not just consumers itself, that it's the city's position that working from home due to COVID is not a legitimate basis by which to change withholdings. That's what the email establishes very clearly. So even if an employee was to change it, and Judge, I want to just take a step back for a second. In March of 2020, how an individual who was working on site, meaning at the what I call campus, but at the headquarters of Consumers Energy, they would have no mechanism by which to know what part of the year they're going to be working because they could be called back to work at any particular time. The problem here is that the consumers reached out to Jackson and said, we want to be able to utilize an alternate method to be able to deal with this because these folks who don't live in the city and are no longer working in the city are still being collected on taxes. And as the email establishes, it's the position of the city that those monies still needs to be collected by the employer from the employees withholding on their particular paychecks. So even if an employee just had the miraculous foresight to know that from March of 2020 to the end of the year, they're not going to be back on campus at all, then even if they were to file a new form, the city of Jackson's tax administrator would not accept that form as a basis to change the withholdings by the employer.
When does the city of Jackson even see the form? You give it to the employer. They don't get submitted to the city.
But the employer, when they get that notice, would then have to turn because at each period of time, the city doesn't get the money at the end of the year. They get regular payments on these throughout the year. And it's
not if an employee submits a form that says I'm not working in the city anymore, or I'm only working in the city 25% of the time, or whatever it is. But at that point, the employer would start withholding based upon the new withholding certificate.
But the employer has to reject that because of the position that the city has taken that says that being working off-site due to COVID is not actually working outside the city limits.
You're telling me that the employer would disregard an amended W-4 submitted by its employee?
Because the city directed them to. That's what the email establishes, I think, quite clearly that, that's the whole point where we're at this particular point of the court case, Your Honor. I would love to be able to present to you the testimony of the Vice President of Tax, who's had the interactions with the city manager and what his interactions were when trying to change all this for his thousands of employees who are no longer working within the city of Jackson anymore. They rejected that. Now, again, this is my understanding in these conversations I have pre-discovery. But the point of this is that the city of Jackson said, we don't care what you think, employer, and we don't care what you think, employee, continue to do the withholdings. And I think, and to the extent that's my understanding, that's our allegation. And I think the email that I'm seeking to propose to add today, which is kind of, I will grant you, is kind of oddly structured about how we're making this motion today. But you got to remember, we're here on a C4 and C8 motion, not a C10 motion.
Oh, I understand that. I'm just looking down the road.
Well,
and that's what didn't make sense to me that if the employer withholds based upon a withholding certificate submitted by the employee, and the employee doesn't submit an amended withholding certificate, what choice does the employer have but to continue withholding based upon the certificate it's got?
Because the employer, in this case consumers, wanted to say that the amount of time that these individuals were on campus is 0. And the city would not accept that because the reason for that rechange of that designation would be that because of COVID. COVID says they're no longer working there. As the email establishes that it's the position of the city, at least from consumers' understanding from the city. Now, maybe consumers misunderstood the city in some fashion, but these guys are pretty sophisticated people in the tax department at consumers. They are under the directive of the city treasurer to continue to collect, and that a change in the designation of what those individuals are, or the employer made, the employee made change, are ineffective and means nothing on behalf of the fact that the tax administrator says continue to collect.
Mr. Hagerty,
one other thought here is, let's say I'm wrong. Let's say I'm completely wrong and off base on what I understand of consumers, the interaction between consumers and the city of Jackson's treasurer's office and how this all panned out, right? Even if I was wrong in that respect, the remedy would be, one of the remedies would be is if the city's already returned the money pursuant to a tax refund, the city has denied all of these individuals the opportunity for interest. So,
and I understand that.
Okay, and let me just add one more. As I understand it as well, and if the consumers doesn't obey what the city tax administrator has directed, the employer gets penalized on top of that. So, what's the employer supposed to do? Even if an employee says change it, the city tax administrator says don't change it. And by the way, employer, if you change that, we're going to penalize you too on this. That's the whole point of this case, is that they're not allowed to use the guise of a tax to collect money. They're not otherwise allowed to collect as an unconstitutional exaction that way.
Hmm.
Now, and finally, by saying, if things had applied very cleanly and very neatly, how it was supposed to have been done, how I think the statute was intended to be done, we probably wouldn't be here. But what it was is a circumstance where the city wanted to continue to collect its money, even though it couldn't. They'll say, you know what, we're getting an interest-free loan during this time. We want the additional monies coming in. But that denied all of the individuals who are no longer working within the city to have their full income, at least minimally the interest and the time value of their money that was taken from them.
So, Mr. Hagerty, could you speak to the issue of the question I raised about the JW4 form and what it is? if an employee changed their JW4 with the employer and the employer then honored that change and started withholding at a different rate, what would have happened?
The tax wouldn't be collected, Your Honor, and you hit the nail on the head. And I'll go back to a point that you had made during the initial argument back last month on the 19th, which is if say for the sake of argument, the county decided to have all circuit court judges work remotely, and you're no longer working in the city, you're in Clark Lake or wherever, you wouldn't then be obligated to pay city income tax because you're not working within the city limits. Now, you could easily, as you alluded to, amend your W-4 as the statute allows, change your allocation by and between yourself and your employer, in this case, my example, the county, and the county would not withhold that income tax based upon your representation that you're no longer working within the city limits. The city has no way to know whether it would be you or somebody at a widget factory, any other employee who works in the city who doesn't reside in the city, what their withholding is. That's by and between the employer. And we have to go back in the big picture to realize that we're discussing factual issues regarding allocation versus withholdings. And I think Brother Counsel is kind of mixing apples and oranges here with regard to this email. But the threshold, as this court's well aware, the threshold issue here is Your Honor's jurisdiction to even adjudicate this. So as I pointed out in my brief, if in fact consumers took too much money from Mr. Hoffmeister in this case, then his remedy is to file an income tax return, allocate like hundreds of employees throughout the city have done and received refunds thus far. The city income tax return deadline's been extended until June, and our tax administrator has been firing off refunds left and right for allocation. What Mr. Ellison, I think, tries to confuse is this issue of withholding at all. There is no edict or mandate that the city can impose to say, consumers, you have to withhold or not withhold monies between a particular employee, in this case, Mr. Hoffmeister and his employer. That's between them, and that's a function of the statute. It's not, there's no practical way, Your Honor, for the city to know the individual comings and goings of every employee at Consumers, let alone all the other employees who work within the city. And so there's this misnomer with regard to this email, and that's why I attached the exhibit that was the correspondence between the administrator and the consumer relations, Ms. Bradish Orta at Consumers, that detailed they were talking about allocation. And in fact, the email from Mr. McIntosh references or attaches a spreadsheet telling employees, hey, here's how I allocate and get my refund for the time I don't work in the city. You should do it too. The city has honored that as a method. The only thing that the tax administrator objected to is this blanket form Consumers wanted to use. So back to your question, Your Honor, 100% an employee could revise their withholding. It doesn't start, stop, and end at the time of their employment, and it would never change. If someone's working at Consumers and gets sent off to Parnell Road and isn't working in the city limits, it would fly in the face of all logic and reason that Consumers would continue to withhold city income tax when they're not working in the city. And so the employer would make the change. They would not withhold the income tax. They would withhold the income tax from those people that work in the city and pay the money. But fundamentally, if Mr. Hoffmeister, and again, the city has no, and this is important, Your Honor, with regard to the C8 portion of my motion, the city has no record that Mr. Hoffmeister is a city income taxpayer. So he comes to the court and there's been no evidence or argument that I've heard that he is in fact has ever paid city income tax. And so you've got a purported class plaintiff that may not even have standing if he doesn't pay taxes. And the remedy for he or any other taxpayer, Your Honor, that has an issue with how an allocation was made, go to the Income Tax Board of Review or take it to the tax tribunal. What Mr. Ellison is attempting to do is to get thousands of people who may have some argument about interest, which isn't consistent with what the statute provides, as I cited in my brief, and bring them to the court, flood the court with 1,000 plaintiffs, all of whom, if they had an issue, would go to the Board of Review and the tax tribunal, just like a real property petitioner if they thought their assessment was too high.
All right. So thank you for addressing my question. I realize it is beyond the jurisdictional issue, but I wanted to understand if we ever got past the jurisdictional issue, is there anything to this case anyway? So that's where I was coming from. So Mr. Ellison, the specific reason you're here today is to seek leave to amend your complaint. Is that correct?
Yeah, so Judge, I will acknowledge this is a bit structurally weird because of the nature of the arguments last time. It's our position under C4 and C8, well, let me back up and say it this way. Under C8, the court can't look beyond the pleadings. And Mr. Haggerty, for example, just made a statement that my client didn't produce evidence. We're not at the evidence stage. C8 is solely on the pleadings itself. However, C4 does permit the court to look at evidence beyond the four corners of the complaint itself. The concern I have, and Judge, it happens all the time. I'm not saying this was wrong in any respect, but we went way beyond the four corners of the complaint, and the city did not provide any evidence that it attached to its motion for summary disposition. The problem I was concerned about was, and I'm hearing it again today, is that the city's presentation of what it asserts occurred versus what our position says occurred is being presented as if it's fact. And I know as a plaintiff's attorney who sues governments quite often, the word of a government attorney sometimes is taken as like the 11th through 15th commandments coming down the mountain. And I'm not faulting that Mr. Haggerty misrepresented anything to the court, but I think what it is it's just not an understanding of what's actually going on in the field. In the field, as I've attached as an exhibit, and I'd like the court to be able to utilize as part of the pleadings itself, is that that Consumers Energy sent a communication out outlining that the city stated that working from home should still be taxable to Jackson. And then it went on to talk about the arguments about what substantiation is required to show work outside the city, and that the city did not agree with consumers' position that working from outside or working from home outside the city limits is a non-taxable event. Now, ultimately, maybe I'm wrong. I don't think I am, but maybe I'm wrong in this respect, that consumers, as we understand it, and Judge, I did speak to folks and consumers about this very thing, and the issues involving this, and what I've presented previously is their understanding as well. So I get there might be a disconnect from what the city attorney's office thinks ought to happen versus what is actually happening, and we're suing on what is actually happening. So what we'd like to be able to include is the email that substantiates our position. Now, the court has two methods. It can accept it as an exhibit, which again, you got to be careful because you can't use it under C8. You can only use it under C4. Or an alternative is allow me to attach it as an exhibit, as an additional exhibit to my complaint. And I applied for that in the alternative. I guess it's whatever the court's preference is. Myself personally, I think it would be better to attach it to amend the complaint to attach it, so then it could be utilized. But that's up to you how you'd like to proceed forward. But I didn't want the record to be unclear that the city got to make these assertions without us and trying to essentially say that we didn't know what we were doing in that respect, when in fact we believe the facts are as we present them, and the situation is such different than what the law actually is prescribed here.
I don't have a problem with allowing you to amend your complaint. We're early in the proceeding. Frankly, I don't think it's going to make a whole lot of difference as to the pending motion to dismiss for lack of jurisdiction, because as argued, it's exclusively within the jurisdiction of the tax tribunal. I don't think the memo makes any difference in that regard. And I owe you a decision on that. And frankly, was pondering it when we got this additional filing. And I thought, as long as you guys are going to be here today, I wanted to quiz you about this W-4 and the provisions that created under the income tax code. Just because it seems so obvious to me that this whole issue could have been circumvented simply by employees filing updated W-4s.
And perhaps it would have been had the city allowed consumers to do that, but I think the email establishes they were not allowed to do that. Now, again, maybe Mr. Haggerty's got different evidence that's available that once discovery starts and we can start deposing each other's witnesses and, you know, finding out exactly what happened. But from my client's perspective, he wanted all of his money. He wanted all of his money because he wasn't working in the city. And what happened is the consumer said, no, we have to collect it based on the directive that the city tax administrator directed us. And this email substantiates that. So anyway, so long story short, and, you know, as I'm kind of smiling to myself over here, surprise, surprise, judges are using the internet and looking outside the record in cases, right? So that was my concern, that, you know, sometimes when judges and judges clerks go on a research bender and starts pulling up city websites and city forms, much like you just indicated, which is beyond, I think, kind of the scope of the record. We want to make sure our position is clear about the fact that we are disputing what's happening on the ground versus perhaps what the city attorney's office thinks should be happening based on the language of the statute. And we wanted to make sure that was clear for the record.
All right. Well, I readily acknowledge the questions I had about the W-4 are beyond. We don't even get to those questions if I find that that I don't have jurisdiction. But I wanted to know the answers.
Very good. Very good.
Okay. Thank you, gentlemen. Mr. Ellison, you may amend your complaint. And hopefully I'll be able to get a decision out to you in the very near future on the jurisdictional issue.
Very good. Thank you, Your Honor. Appreciate it. I'll submit an order to the court and I'll file my amended complaint.
Thank you, Your Honor. Just a final, very brief matter of housekeeping with regard to the court's order concerning the amended complaint. I of course, provided Exhibit 1 to my reply, which is essentially the reply to the contention of plaintiff regarding the Macintosh email. And so I just would request the court take judicial notice of that in light of the amended complaint, but again, acknowledging that we don't even get there if the court finds in the city's favor with regard to the jurisdiction.
Well, and you get to file an answer to the amended complaint, and you can certainly include in your answer this issue. So at least it'll all be contained within the pleadings. I don't think it's going to make any difference, but I don't ever like to deny somebody the opportunity to file an amended complaint, particularly when we're this early in the proceedings.
Okay.
Understood.
All right. Thank you,
Okay.
Judge.
Thank you, gentlemen.
Yeah,
Have a good
Thank
day.
you.